Here are 5 things graphic designers should know about copyright in Australia. Number 1, copyright is automatic. As soon as original work is created, copyright protection starts. You don't need to register anything, at least not in Australia. In some countries, such as the USA, you have to register your copyright first if you want to sue somebody for copying you. Now notice that I said original work. Now that's important because you have to have created something original to deserve copyright protection in the first place. Copyright is actually one of a handful of laws covering creative output, and it's most useful for designers. Your client, on the other hand, should, where possible, rely on trademarks law for corporate identity work, not so much copyright. And as a design professional, it's something you can encourage them to be aware of. That's a different topic which I might cover in a future video. 2, there is no copyright in an idea by itself. You see, copyright doesn't exist until ideas are expressed in a tangible form. For example, a sketch or notes. You see, discussing an idea with somebody else does not give you copyright over the idea, even if it's an original idea and it's your idea. You have to create a physical or electronic record. So it's helpful to keep good notes on your idea development and concepts, and ideally make sure they're dated. 3, copyright can be sold or rented. Think of copyright like a house. And once you've built a house, you can sell it outright. In copyright, that's called assignment. Or you can rent it out, which in copyright is called licensing. You don't have to rent out the whole house. You could rent out just the garage. You could rent out 1 or 2 bedrooms. You can rent it for a day, a month, or a year, or 2 years. Well, the same concept applies with copyright. You can have limits when you license your copyright to somebody else. For example, you can tell them that it can only be used for a limited period of time. You can control where it's used geographically, right? What locations, who can use it. And if it's something that can be produced, well, the quantity that can be produced. You can limit all of this. The time when this is particularly useful is when a client tries to get you to lower your fees, right? They might say that they don't have the budget because the project is just for a short campaign in some rural towns or some limited distribution. In this kind of situation, if you agree to discount your fees for them, what you can do is you can write a document that clearly explains the terms of a license to allow the client to use it exactly as he's telling you. That way, if your work later gets used elsewhere or more broadly, you can benefit from additional fees. 4, copyright means don't copy. There is no such thing as a 5% rule or a 10% rule, right? That's an urban myth that if you change something by 5 or 10 or whatever amount, it's okay to copy. That doesn't exist. Where I think it comes from is the practical reality. If you were to change something so much that the original creator no longer recognizes it, then they won't know to sue you or make any kind of legal claim. But it's not a specific amount, and honestly, I'm not sure how you would define a 5% change versus a 15% change anyway. 5, copyright can be expensive. Now here's a dose of reality that we have to consider. I'm talking 5 to 6 figures to run a court case. Because of this, less than 1% of cases goes all the way through court to where a judge hears the case and hands down a judgment. Actually, it's much, much less than 1%. In the vast majority of cases, a settlement will be negotiated if there is a dispute. So what does this mean for you? It means the more legally watertight your evidence, the better the outcome. And because it's so expensive, it's worth it to put in the effort at the beginning instead of thinking that the court will sort out the problems for you. Think back, for example, to what I said about licensing, right? You make sure that the document contains all the restrictions very, very clearly with no room for misunderstanding. Any misunderstanding will just be a weakness that could potentially require more time in a court case. Now, even before you get to licensing it, keep good records of developmental ideas and concepts. See, the better documented everything is, the better the outcome that your lawyer can negotiate for you. So those are the 5 things that I think designers should know about copyright. I'm interested to know if you've had any kind of copyright issues, so let me know in the comments, and if there's any common problems or questions, that's something that I'd consider to cover in a future video.